Before we begin this podcast, I would like to start with an acknowledgement of country. I would like to acknowledge the traditional owners of the land that I am on when recording this episode, the Wurundjeri people of the Kulin Nation, and pay my respects to their elders past, present, and emerging. I would also like to extend that respect to the two Indigenous women who will be joining me on this podcast, and acknowledging that sovereignty was never ceded. This is the Constitutional Reform episode of the Yarning Circle podcast, and I'll be talking about the Uluru Statement from the Heart, what it calls for, and why it is necessary. What is the Uluru Statement from the Heart? It is a plea from First Nations people to the Australian public for substantive constitutional reform. The Statement from the Heart calls for 3 areas of reform: voice, treaty, and truth. The first reform is the constitutional enshrinement of a voice to Parliament. The voice will empower First Nations politically. It will be a permanent institution for expressing First Nations views to the Parliament and government on important issues affecting First Nations. The specification that a First Nation voice will be constitutionally protected is an important one. Aboriginal and Torres Strait Islander peoples have extensive experience of fluctuating stability where Indigenous advisory bodies have been created and dissolved due to changes in government and political priorities. The Uluru Statement calls for a stable platform, guaranteed by the Constitution for First Nations voices to be heard now and into the future. The second reform is the Makarrata Commission to supervise a process of agreement making between governments and First Nations, and truth-telling. Voice, treaty, and truth provide a clear and practical path forward for First Nations self-determination in accordance with the United Nations Declaration on the Rights of Indigenous Peoples. My name is Neane Carter. I'm a Yorta Yorta, Dja Dja Wurrung, and Wamba Wamba woman, and I'll be yarning with 2 inspiring Indigenous women, Professor Megan Davis and Bridget Tharma.
My name's Professor Megan Davis, so I'm a Cobble Aboriginal woman from southwest Queensland.
My name is Bridget Tharma. I am a Wiradjuri woman from central west New South Wales.
Awesome, thank you. I was just wondering if you, Professor Davis, and Bridget, if you wanted to add anything, what are the main criticisms or myths about the Uluru Statement from the Heart and how this may be debunked?
Well, there's a couple, I think. I suppose 2 I'll start off with, and Bridget, you can add more if there are any more. The first one is to do with sovereignty, and the second one is to do with third chamber. I'll knock off the third one first, though, because third chamber was a little slogan that the LNP came up with when Malcolm Turnbull rejected the voice to Parliament and the Uluru Statement. And I think Barnaby Joyce used it first, that it would be a third chamber, meaning you have the House of Representatives, the lower house, and we all know that that forms the kind of government because it's the popular vote, it's the number of Australians. And then you have the Senate as a chamber, the upper house, which is meant to be states representation, but it's not anymore. It is, but they vote along party lines. And the argument was that asking for an enshrined voice to Parliament creates a third chamber, meaning it violates the Constitution and all kinds of principles of representative democracy and equality before the law. And in any event, multiple former High Court judges have now came out to say that, the third chamber was mischievous and disingenuous and false. And it's not a third chamber. All it is the right to be at the table when laws and policies are made about us at a Commonwealth level. And we know that if it's at the Commonwealth level, then it will imbue the rest of the Federation, meaning we would need to be at the table for state government and local government laws and policies as well, or bylaws. So the third chamber is kind of manageable. Really, we're just compelling the state to have us at the table, and that's a really important right. The first one, sovereignty, is again not so difficult to dispel, but it is difficult to dispel I think people who have been opponents of constitutional enshrinement do believe it. But so the argument goes that enshrining a voice in the text of the Constitution means we cede our sovereignty. So there's a few things to say about that. The first thing to say is nobody cedes your sovereignty unless you willingly cede it. And as far as I know, no Aboriginal group has ceded their sovereignty. So there's no act of the Commonwealth Parliament, the High Court, for example, that could cede our sovereignty. It's not the way sovereignty works. Even the High Court in Mabo and other decisions have said, look, we can't talk about sovereignty because that is a sovereignty that isn't recognised in this legal and political system because it's imposed upon Aboriginal communities, Aboriginal groups, or First Nations peoples. And so, we sit in a contested kind of space. And for us to cede our sovereignty would be us saying, that we absolutely, agree to be a part of this system and to fully assimilate to those legal and political mores, I guess. Since 1901, or even since first contact, there's been no significant act done by the Crown that has had an implication on our sovereignty. Not first contact, not the Frontier Wars, not the 1890 debates that led to the drafting of the Constitution, the passage of the Constitution, and then its commencement in 1901 didn't affect our sovereignty. 1967 referendum, we saw the deletion of our exclusion and we were included in the Constitution via that referendum. That didn't change our sovereignty. There were no Aboriginal people at the time saying if we vote yes in this referendum, it's going to cede our sovereignty. So it is not the case that a voiced parliament will cede our sovereignty. The really key thing for people to keep in mind is that the thing that does lead to a shift in sovereignty are treaties, because treaties are what people enter into traditionally at first contact as a way of coming to a settlement and an agreement on sovereignty, and it might be shared sovereignty. It might be overlapping sovereignties, and or, as in many cases around the world, the US, Canada, etc., it is the ceding of your sovereignty for particular gains. So it's really treaty where you get down to the nitty-gritty of sovereignty. Something like recognition in a constitution isn't going to do that. That took ages. Sorry.
No, that was perfect. It actually leads in well to the next question I was going to ask, which I could probably chop it a bit, is what's the difference between the Uluru Statement from the Heart and other conversations going on around the country around treaties, especially with, Treaty Victoria, which has a lot of traction. And especially I found talking to family members who are really on board with the treaty movement here, trying to get them understand what the Uluru Statement from the Heart is really difficult, because they really, really believe in it, and they really believe this will change. This will be the change they need. And when I've listened to you talk about, the thing with treaties is, they can be good. I mean, the Uluru Statement from the Heart, one aspect of it is treaty. However, the idea is that can be taken away as quickly as it can be given. If not quicker, then it can be given. Yeah. And so it's about ensuring that, when this treaty is established, it's not something that can be changed just because government decides they don't want that agreement anymore. And it's almost like that doesn't make any sense. I think there's still too much faith that if, the state government says we'll listen to Aboriginal people, they will, when time and time again has shown that they don't.
They don't. And look, in the Federation in Australia, states don't have much power at all. So one of the key things I think we come up against is a lot of Aboriginal people, when they talk about treaty in Australia, are using a British Columbia Treaty Commission example. Canada is a completely different constitutional creature to us. When British Columbia is entering into this kind of new post-colonial treaty-making process, which is different to their kind of comprehensive lands claim system, they have the backing of Section 35, a constitutional right within the text. They have the backing of the Canadian Charter of Rights and Freedoms. But one of the key things is both countries are constitutional monarchies that are federal systems. But the big difference is this: their Supreme Court has worked really hard to ensure the provinces, have maintained their constitutional power. Our High Court went completely the opposite direction. And so over the years, a century, they've chipped away at states' rights. And with the Senate not functioning in a states' rights manner in the way that the drafters intended, our states don't have power, meaning you can enshrine, and that's the strongest you'll get, and it's not really an enshrinement because the Victorian Constitution is no different to other states. They're ordinary act of parliaments, meaning you can pass legislation once you negotiate your treaty. But yeah, there's a Commonwealth override that can say, look, we're going to pass a law that's inconsistent with that provision and knock yours out entirely. So they're not secure. The biggest thing I think, though, about why a voice, and I understand why people feel that way about treaties, because we all want treaties, right? Treaty was still, one of the most prominent reforms on the table for Uluru. The key was having an institution to manage agreement making across the Federation. And one of the things about the British Columbia treaty process, which I think, a lot of Victoria's work is predicated on that, because that's the most recent kind of contemporary analogous example that everybody uses in Australia, is they've negotiated very few successful ends in terms of finalised treaties. Treaties take decades and decades and decades to negotiate, and it's more difficult for states or provinces because often negotiations change according to the government that's in power, because treaties are just as much about law as they are about politics. So sometimes some tribes might hold off on certain things and wait for a Labor government to come in or a Liberal government to come in, because you know that it's going to up the odds of you being able to settle a particular negotiating table, so that a particular substantive issue you really want to get substantive rights on, you might do a little bit of political strategy about who's coming up and who might support a particular thing. So, look, they're really complex legal agreements. As we're seeing in other parts of the world, it takes a long time to get, you're about to go into a process where you're going to negotiate your framework agreement. And the Victorian Framework Agreement will set out, a framework agreement is basically a table of contents for a treaty. And you guys are going to have to negotiate that with the state. And that will set out what the substance of your treaty is. And then you've got to start negotiating each item. They're difficult, and it's really important, I think, for the Assembly to manage community expectations that is going to be quick, and that it's going to deliver things quickly for people, because it hasn't been the case in most parts of the country, most parts of the world.
Sorry, Professor Davis. Bridget was mentioning that you'd recently written an article talking about closing the gap. So if you just want to have the floor and just talk about that, or what you think about health, that'd be awesome.
Yeah, so I think it was really interesting this year when kind of Black Lives Matter really became prominent in Australia, particularly around incarceration and youth detention. But kind of almost at the same time that closing the gap was being wrapped up as well. So you had this kind of confluence of health and criminal justice swirling around, and people asking, what then is the relevance of the Uluru Statement and a constitutionally enshrined voice to that. And it's an interesting question, because a lot of people quoted from the Royal Commission into Aboriginal Deaths in Custody. And, the interesting thing about that report, well, there's a couple of really interesting things that help us, think through these issues and how they're all interrelated. But But the Royal Commission into Aboriginal Deaths in Custody, I read the whole report for my PhD, so I know it very, very well. It was one of the most comprehensive Royal Commissions, I think, ever, not unlike the Royal Commission into Aboriginal Peoples that was held in Canada and led to really substantive legal changes in Canada. With our Royal Commission, it looked at, the almost 100 deaths in custody and had found and concluded that none of them were, deliberately done with intent at the hands of police or prison officials, etc. But virtually all reflected a lack of duty of care for people in their custody, which I think is pretty accords pretty well generally with the Australian legal system. I think when it comes to Aboriginal and Torres Strait Islander matters, I mean, we're well past the place, I think, of people would say maybe not metaphorically, but we're well past the kind of protection era and the dying pillow kind of phase, in that Australians believe enough in the rule of law to say, look, all things are equal, everything applies to Aboriginal and Torres Strait Islander people. But it's, you look at some of those coronial inquests in terms of deaths in custody in the past few years, and it's pretty clear that the rule of law doesn't apply always to our people. And there's a lot of poor practice and lack of duty of care when it comes to our people. And I say that as somebody who was a commissioner for Queensland's Royal Commission into youth detention centres. So I was one of two commissioners that investigated really serious allegations against prison guards in the two major youth detention centres and one of some of the units in the major adult prisons. And you could see, and we used the Royal Commission into Aboriginal Deaths in Custody Queensland report to get a sense of what's going on in Queensland. And the past 2 years I've been leading an inquiry into Aboriginal child removals in New South Wales, where I've found a lot of poor practice when it comes to social workers, but also really poor practice when it comes to the courts. For example, social workers putting in paperwork to have children removed for families. We've found through the course of our deep dive into these files that a large percentage shouldn't have been removed, that the caseworkers didn't have evidence on file, but that the court didn't look behind the file because they expect, the minister to be a model litigant. We know this happened in Queensland as well, where, caseworkers were lying to the court. And the court wasn't checking the facts or the evidence. And so you see our children being removed for reasons that they should not have been removed. So I can see with those two hats on that lack of care and disinterest about our people in the system in those areas where our people are most vulnerable and most acutely impacted. And so what the Royal Commission then said was, look, there are things that we can do in the criminal justice system to make it fairer for our people and to protect them. So I think I know I've rambled a little bit, but there is, I think the Uluru Statement is ramping up a little bit what was done in the Royal Commission, and that is just really openly saying, you know what, without structural reform, everything is tinkering at the system. And without structural reform, it's lipstick on a pig. And without structural reform, there's not going to be any change.
Yeah. Bridget, do you want to add anything?
I guess what I was talking to you about the other day was more related to how, our young people see the Uluru Statement and the reforms it calls for, particularly a constitutionally enshrined voice, how that will have an effect on the ground in our communities. And one of the experiences that does stick with me and that I have talked about before is a group of young Aboriginal women from Central Australia who I met at the Uluru Youth Summit. And when we sat down and yarned about the Uluru Statement and the impact that it would have, they talked about Black deaths in custody. And at that time, Mr. Walker had just passed away in Central Australia, and it was, a Black deaths in custody matter. And they talked about how important it was to tell their community about the Uluru Statement and the impact that a First Nations voice enshrined in the Constitution would have on matters such as Black deaths in custody. And that was just something that really stood out to me and that I hold close to my heart when I think about the impact that the Uluru Statement can have on the ground.
That concludes the episode on constitutional reform. What action you can take now in supporting the Uluru Statement from the Heart can be found in the description box below. This includes registering your email on the website to receive notifications, donating to the UNSW Indigenous Law Centre, which is the only organisation recognised by First Nations communities as having the cultural integrity to meaningfully and substantively advance the voice, treaty, truth agenda. And the Uluru Statement from the Heart website has a lot of resources that people can read to educate themselves on the movement. Stay deadly.